Hello, welcome to This Family Does Everything. My name is Alexandria, and this is part 4. So without further ado, let's sit back, watch, and analyze the Darrell Brooks trial.
I have the right to face the injured party claiming damages. That's under Article 3 and the 6th Amendment. I raised that issue again. Where's the injured party? Is the injured party present in court right now? Can anyone make a claim against me? Can you make a claim against me, Your Honor? Do you know of anyone that can make a claim against me, Your Honor? Can anyone right now in court, anyone, make a claim against me? And because of that, Your Honor, the motion to dismiss should be granted based on that alone. There's no injured party in this matter. So who makes the claim? Who? I have the right to put the judge on notice of my intent to appeal and any ruling decisions during the case. You stated for the record that I would have to wait until appealing process, but my right is that I can raise that issue during the case, which I've attempted to do. That's been shut down. I have the right to specifically reserve all of my rights, which I do at the beginning. I have the right to say what I want and to be heard under the First Amendment. And when I attempt to do that, it's taken as a slight to the court, a disrespect to the court, or me intentionally coming into the court to be disrespectful, which I've stated that is not my intention. Never is it my intention. I never intend to walk into your courtroom, Your Honor, and be disrespectful intentionally. I've repeatedly asked the court for a motion for a finding of fact to determine if things are being done legally. I've been denied that numerous times without merit, which is also my right. I have the right to recuse the judge at any time, which is also a right. I have the right to a speedy and fair trial by impartial jury. I think it's safe to say that my speedy trial right has definitely been violated because this matter has been taking place for roughly a year. I've never consented to waiving anything related to a speedy trial. And if that was done, it was done without my consent or without my knowledge. We're way past the speedy trial date. Way past. When the change of venue motion was brought up, I believe that was the first time I came before Your Honor in early March. I want to say March 11th of this year, when the change of venue motion came into play. It was decided by Your Honor that wouldn't be decided until the 20th of June, I believe. That's over the 90-day mark right there for a speedy trial. That was denied, and I still don't understand how that was denied when it's clearly obvious that at minimum the venue should have been changed based on the fact of the magnitude of the matter. There's no possible way anyone in this county would not have some type of connection or some type of knowledge, whether they were told something by someone that they may know. The news reporting alone, just that alone, there's no way that this trial should be taking place in Waukesha County. That's obvious. That's obvious from the way the motion was presented. the coverage alone, the political campaign ads that plastered the defendant's face all over the TV every single day. Every time a political campaign was brought up, it made reference to this incident. Every single time. The fact that people have children that go to the same schools in this county, that people may have worked with the same people in this county. You yourself, Your Honor, stated that you at one time worked with the father of one of the people that was injured in this matter. That is a clear conflict of interest right there. You also stated for the record that not only did you work with this father, but that at one time they may have donated to your, I don't know if it was to you becoming a judge, or I would have to look through the docket, but you said it on the record that they donated money to a cause of yours. You also stated that when you had gained knowledge of the incident and that their family member was injured in the incident, that you reached out via phone. I don't recall if it was text message or an actual phone conversation, but you put that on the record. You also stated that the nature of your relationship was strictly professional. I don't know about you, Your Honor, but I've worked numerous jobs, and I know what professional relationships is and personal relationships. I've never had the cell phone number of anyone that was a personal relationship saved to my phone that I could reach out immediately when I learned something. That would constitute a personal relationship of some kind. Whether hanging out from time to time, having a cup of coffee, or hanging out time from time, grabbing a beer, or hanging out from time to time, watching a game, or anything of that nature. It would definitely be more than just strictly professional. That was stated for the record. Again, I go back to the Sixth Amendment again. In terms of when I asked for the motion for the evidence motion that I raised, that was denied without any explanation. That would be strictly to place in the evidence any unrevealed contract. That's under the Sixth Amendment. Clearly, there's been repeated violations of my Sixth Amendment. We all know that the United States Constitution is the law of the land, period. It trumps everything. We also know that any law repugnant of the Constitution is null and void. We know that. There's still no basis for the motions being shot down. Why was I not granted the motion for finding a fact? Why did it take so long for me to be brought my entire motion for discovery? Why was the motion to prove jurisdiction not verified? Why was the motion to dismiss the case for all the reasons I said not being granted? Which brings me to the motion to subpoena witnesses. I did everything that was asked of me by the court pertaining to those subpoenas. It was understood by the court that this is my first time ever having to do this. I didn't understand how to properly fill out the subpoenas, at which the prosecution volunteered that they would give assistance. The only assistance I received was for them to check to see if it was filled out right. That was it. That doesn't amount to any assistance. I was still left to fill it out on my own, and then when I did that, corrections still had to be made, which would verify what I was saying. I don't know how to do this. But I still complied to what the court asked of me. And even then, it was a big old thing about the subpoenas. I can't subpoena the plaintiff in the case. Well, how can I not subpoena the plaintiff in the case when under the Sixth Amendment, I have the right to face my accuser, which is the plaintiff of the case? So how could the subpoena not be filed, and how could the plaintiff not be called to the witness stand? That begs the question of, does the plaintiff even exist? Which it was stated for the record that not only by a witness, a detective Casey, that got on the stand and said on the record that is an entity, which is not a living, breathing human being. And then it was stated again by you on the record, Your Honor, that the plaintiff is an entity. So the question still stands. How can an entity bring a claim if it's not a living human being? So where's the claim? Will the plaintiff in this matter, the state of Wisconsin, be allowed to testify? Will they be allowed to be in the courtroom? No, they will not, because they don't exist. Therefore, the claim doesn't exist. For all those reasons that I just stated, the case should have been dismissed a long time ago. Once those issues were raised, this case should have been dismissed. And at the very minimum, it should have been dismissed because those still have yet to be proven. We're still talking about jurisdiction. That's been being asked for over a week. There's still no providing of license to practice law yet. Not even by you, Your Honor. Why was I not provided with a certified copy of your oath of office? Why would you not state the name that is on file with the Secretary of the State? Or I made reference the first time to the Secretary of the Treasury, and then you stated on the record that it's the Secretary of State, even though you knew what I was referring to when I asked. You referred to your name tag, but that's not the name registered. We both know that. So why wasn't that proof verified? You gave me a copy of your oath of office, but it's not certified. So how can I verify that that is the true oath of office that you signed? How can I verify that it's valid? That's the reason why I asked for it to be certified, which you stated for the record you will not do that. You never stated any legal reason why. I have the right to ask for that legally. I also have the right to call any witnesses to assist my defense, which is the main reason why I subpoenaed the plaintiff in this matter. I also have the right to challenge all relevant laws in this trial in terms of their intent, interpretation, fairness, enforcement, and whether they serve and protect the people. From my knowledge, the design of the statutes of the law was written for the common people to understand. So that would mean the final determination or interpretation of what the law says comes down to the people. You know this, Your Honor. Are you or are you not a public servant? You also know that this docket sheet is inaccurate. Every filing up until the point that I started representing myself was filed in a name that was represented by all capital letters, which is not my name. Nor has it ever been my name, nor have I ever seen that name or individual. Every single filing or paperwork was all in capital letters. Ever since September 29th, roughly around there, now everything starts to go to lowercase letters. Why is that? What prompted the sudden change? I still have filings that have all capital letters, which I state every time I come into your courtroom, Your Honor, that is not my name, nor do I consent or agree to being called that name. My name is Darrell Brooks Jr. I'm merely here as a third-party intervener on behalf of my client. Did I accept for value in return for value? We go through this every time I come here. Every time. You bring up Illinois versus Allen when we had the issue of me being removed from the courtroom. We went through that where Illinois versus Allen states that there are three options when a defendant is being disruptive in court. You stated for the record that you identified a fourth one, which is not cited anywhere in that case. It's not cited anywhere. So the question would be, how did you come up with a fourth option that's not written in that case? Did you take it upon yourself to add this fourth option to justify denying me my constitutional right by being present? You could have done the three that were stated. Any one of the three you could have done that were stated in the case. Nowhere does it say you can create a fourth option. Not upholding my constitutional rights. I'm sure you know about Title 18, USCS 2381, which states that it's treason not to uphold your oath of office. Treason. You repeatedly make judicial determinations that clearly prejudice my defense. And then when I question you about, are you making judicial determinations, I'm repeatedly shut down. Which leads to today. The constant push not to have an informed jury. Not giving legal valid grounds on objections, not noting objections for the record to make sure that the record is clear. I'm sure somewhere in the jury instructions you inform them that the state of Wisconsin was bringing the claim. But then you make the judicial determination that I'm not allowed to ask questions about the plaintiff. That's clear bias. And it prejudices my defense. You know also that you have an electronic filing system. I find it hard to believe that I was told yesterday about my subpoena for the plaintiff that I had to wait for a filing in a timestamp when I've seen it done numerous times in just a few seconds right in front of my face. When the prosecution needs something filed, it's filed immediately. I have to wait, or I have to wait till the next day. That's a clear bias and a clear prejudice to my defense. Obviously, the court knows that I'm not privileged to the same filing system. Which brings me to the reason why I brought up the issue of assistance of counsel. Under the Sixth Amendment, I have the right to assistance of counsel. It doesn't say anything about representing yourself without assistance of counsel. Having counsel represent you and having assistance of counsel is two totally different things. You, Your Honor, gave me paperwork that was a waiver of counsel. We both know that any contract can be altered if I don't agree to certain terms. I crossed out everything in that paperwork that I did not agree or consent to, and specifically wrote on that paperwork that I do not waive my right to assistance of counsel. At the very least, I should have been awarded a standby counsel. Not someone to represent me, to speak for me, but someone to help me do things in a timely fashion. Get things filed in a timely fashion. Get motions together in a timely fashion. Make preparations to get things done that I don't have the privilege to do in my current situation of being housed at the Waukesha County Jail. I gave you back that paperwork and you accepted the paperwork that I altered, that you understood that I didn't agree and consent to those things that were altered. You accepted it and you filed it. That is in the record. I have copies of the same paperwork that you accepted. So when you accepted that, with no objection, that becomes a tacit agreement. But yet, I'm still forced to come in here with zero help. I think it's clear that prejudiced my defense. Knowing that the prosecution has everything that they need for this matter at their fingertips. And I have to jump through every hoop possible to even get things filed in a timely fashion. It was stated for the record that the unit that I'm housed in the Waukesha County Jail, and per Jail Administrator Angela Wallenhoff, that I'm only allowed out of my cell for a few hours a day. So I'm roughly locked down 22 hours a day, not given the privilege to access everything that I should be able to at the time that I should be if I was general population. Arrangements could have been made months ago for me to be at least in some form general population with an upcoming trial. Reference was made to being able to use LexisNexis or whatever it's called. We call it the law library. That may be the easier way to describe it. I'm only allowed to access the law library at certain times during the day. The rule of the jail is that when you're not in the day room, you can't access the law library, which is on tablets. We are not allowed to have those tablets in our cells. That prejudiced my defense. How can I work on my case? How can I look up certain case laws? How can I do any of this if I don't have full access to it? I even suggested some type of order that could be made by the court to allow me more time out of my cell, or to talk to jail administration about allowing me more time out of my cell to be able to use those when needed. And to be frank, in a proceeding of this magnitude, there should not be even a time where I don't have access to the materials that I need. If I'm not in the courtroom or sleeping, I should be awarded the time to work on this case, seeing as how I only had a couple days to prepare for a trial of this magnitude. Which brings me back again to the change of venue again. Even right now with trial going on, there's still political ads being shown every day that reference this incident. There's still talk throughout the jail about it. There's been a ton of hate mail received to the jail since the beginning of this. It did die down for a little bit, but it picked right back up the closer we got to the trial. Hate mail that comes from people right here in the city of Waukesha. Which gives more credibility to the venue needing to be changed. Yet and still, that was denied. It's impossible for impartial jury to be found in this county, and that's not to discredit people in the county that can be impartial. It would be unfair to say that no one can be impartial. That wouldn't be accurate. But with the level of scrutiny that this whole incident has, the reporting, the Facebook groups, the constant, there were Facebook groups created because of this. The reporting live stream on Court TV has comment sections where a lot of insensitive and nasty things are said. The sheer insensitivity of some of the things that are said on there. I know a lot of people probably don't care about what I'm about to say, but it still needs to be said because it's truth. The fact of the matter is, that I have children too, family too, loved ones too, that also have been ridiculed and had their names dragged to the mud and have threats towards them. Loved ones that had to leave their home because they were getting threats thrown through their mailbox. Children that didn't feel safe going to school because they were getting bullied behind what was being said. And that's not to sweep anything under the rug whatsoever. To constantly say and report this incident as attack, terrorism. It's unfair and it's insensitive. It's a definite tragedy. Definite. And that will never be swept under the rug. There's always going to be healing that has to take place. It's going to be difficult. And that should not be swept under the rug whatsoever. But it's very insensitive and unfair to not recognize that there's many other victims that never is talked about. And for people to paint a certain picture, mostly from this county, to put this picture out there, it's not only hurtful, but it's insensitive and it's not true. I'm sure the court read through the motion for change of venue. I'm assuming, though it was a lot of paperwork in those motions, I think it was obvious that the venue should have been changed. Obvious. It's too many connections and it's too close. It's too close. If there was any chance for a fair trial and an impartial jury, it should not have been in this county. But yet it was denied without any validity. Zero. There's so much bias that's going on that and even with all this, for the record, we still have no proof of jurisdiction. We still have no bond on file in the docket sheet. We still have no plaintiff. We still have no claim. We're not sure of the relationship between you, Your Honor, and a father of one of the people that was injured. We're not clear on that relationship, no matter how well prepared the speech was, because it was a prepared speech. That was obvious. Where's the proof? I just asked that same question. Can an affidavit be given that there is no bias, no conflict of interest, and no interest in the outcome of this case? There's no proof if you hold the full judicial power of the state, or is it the military power?
Mr. Brooks, I've given you about 50 minutes to make your various arguments. You've now repeated yourself a number of times, so I'm going to turn to the state to see if they have any response. Go ahead.
Thank you, Judge. Judge, I'm going to summarize what I just heard by quoting from a case from the Eastern District of Wisconsin, federal case found at 2022 Westlaw 3045190.
Can you repeat that last
I'm
one?
so sorry. 3045190. Retzloff versus Moran. This case is talking about many of the topics that Mr. Brooks has now recited to the court, and simply states the majority of Retzloff's filing is incomprehensible jargon and cut and paste legal mumbo jumbo. Sovereign citizen theories are frivolous and wholly without merit. And the court goes on to cite to Bay, B-E-Y, versus the state of Indiana at 847, Fed 3rd, 559, on pages 559 through 560, a 7th Circuit Court of Appeals decision from 2017. Mr. Brooks knowingly
consent to being called that name, nor do I know any individual by that name, Your Honor.
Please do the courtesy of not interrupting the state, as they did not interrupt you for over the almost 50 minutes that you spoke. Thank you. Please continue.
Your Honor, the record is very clear that Mr. Brooks knowingly, willingly, voluntarily, and intelligently insisted on representing himself in this trial. He has no constitutional right to stand by counsel, none whatsoever. The court patiently went through the form and advised him of many of the things he's complaining about here today: the resources of the state, the knowledge of the law, his ignorance of the law. And his words to this court, and I quote to the best of my ability, "It don't make me flinch one bit." That's what he told this court, whatever it was, 2 weeks ago. Now he's here complaining over and over and over again how unfair this is to him. It's highly offensive. I don't know, because unfortunately I was talking to my investigator, if he accused this court of treason, but I certainly heard that word come out of his mouth, and it is absolutely shocking that he would throw such a word around so loosely in this courtroom. This court has been exceedingly patient, exceedingly respectful of his rights at every turn. At every turn. I want to address this claim that he only had 3 days to prepare for trial. It's absolutely a false statement. The record should reflect that he does have 3 banker's boxes on his table. The record should reflect that every time the state calls a witness to the stand, he swiftly and easily turns to those boxes, which appear to be alphabetized or organized in some fashion by the public defenders who turned it over to him, and quickly removes the folder of the witness who's testifying and effectively cross-examines that witness using notes from the public defender. We know that because he's tried to confront witnesses with the notes from the public defender. He is not going into this blind or with one arm tied behind his back. They did all the homework, and he's simply sitting here reading their notes, reading their cross-examination questions, and asking the questions, and then going on to his ridiculous questions having to do with his belief in the sovereign citizen movement. There's no way this record would reflect that this defendant is not adequately prepared for trial. He's never asked for a speedy trial. He makes conflicting statements. On one hand, you violated his rights because it's taken us so long to get to the trial, and on the other hand, we're rushing him to this case and he hasn't had adequate time to prepare. He is not denied access to legal materials in the jail. The record is very clear from the jail administrator. It should not be confused. He misleads this court intentionally to say, I only get out of my cell 2 hours a day. That is a fact. That is for his own safety so that other inmates do not inflict physical harm upon him. He has access to a tablet. He has access to a computer. Whether he chooses to ask for those resources is up to him. I would also cite the court to U.S. ex rel. George versus Lane, Lane, 7th Circuit Court of Appeals at 718 Fed 2nd 226, where a pro se defendant attempted to complain on appeal about his lack of access to a computerized legal research system, paralegal training, or law school education. The court rejected that contention and said, once a defendant has asserted his right to refuse counsel and conduct his own defense, he has no constitutional right to access those resources. And again, you warned him, Judge. You fairly warned him. And he basically acted as if you were insulting him and said it didn't make him flinch one bit. Much of the last 50 minutes, which this court has graciously extended him the opportunity to go on and on and on, is nothing more than legal mumble jumble. He's reading from some typewritten transcript. I can see that from where I'm sitting. I don't know who's giving him these materials, but he has an agenda here. It's to stall, delay, disrupt, intimidate, and it's not going to work. Thank you.
Objection to that. Your Honor, that's a load of crap.
Mr. Brooks, that's my opportunity now. I gave you about 50 minutes.
I just want to object to the disrespectful comments that was just made. I'm not trying to hold you up from what you're gonna say, but that's a load of crap.
Mr. Brooks,
for her to sit there,
Mr. Brooks,
for her to sit there,
objection is noted.
For her to sit there, Your Honor.
No, it's my turn. Let me go through this. I graciously gave you 50 minutes to raise all these various points that you want to bring up. I then gave the state an opportunity to respond. That is the proper procedure. I followed decorum. I followed civility. I did not interrupt you. The state did not interrupt you. Your objection to their characterization, it's noted for the record. I am going to render a decision at this point. Please listen, and please do not interrupt. As I indicated, the defendant spoke for about 50 minutes, raising a litany of complaints and issues and theories regarding his view of how this case has proceeded. Many of these issues, if not the vast majority or even all of them, have already been addressed by this court in one way or the other. Looking at, for example, his complaints about change of venue. It is true this court denied the change of venue motion. The court made a record at that hearing. I stand behind that record and that decision. The arguments made regarding that decision, which I would note he has yet to file an interlocutory appeal challenging that, are nothing more than speculative, without a basis in law or fact. To say that this jury is biased would be a complete miscarriage of justice and a mischaracterization of the process this court painstakingly took in order to obtain a fair and impartial jury. There is absolutely nothing on this record before the court throughout these proceedings to suggest that this is a biased jury. I stand behind my previous determination and the process that this court went through, including initially calling an unusually large panel for which the clerk of court's office sent the initial qualification questionnaire, and then ultimately a case-specific questionnaire was sent to approximately 1,400 jurors or potential jurors. There was ample opportunity for the parties throughout the proceedings leading up to the end of August to review those materials. There were numerous strikes for cause that this court entertained. Even prior to that specific hearing, the parties met, they conferred. The state agreed not to challenge the vast majority of the challenges to jurors brought by the defense. Then there was the hearing. Then this court, at jury selection, allowed for an indefinite number of strikes for cause. Many were granted, if not all. And then even on the day that the jurors were brought in, the court provided the jurors with a supplemental questionnaire dealing specifically with the issue of exposure to the political advertisements. And then each party had the opportunity to exercise 10 preemptory strikes, which is well above the number of strikes allowed for by statute, which would be 6 based upon the homicide charges, 1 extra for the alternates, which would be 7. But out of an abundance of caution and in the interest of justice, the court gave each side 10, for which many of those Mr. Brooks chose not to exercise. And then pursuant to state law, the clerk of court chose names to strike by lot. Again, there is nothing on this record before the court to suggest that this jury that we have is anything but fair and impartial. And I take issue with the characterization that they are anything but. They've been diligent, they take notes, they are attentive. They come to this court, as the case law says, there's a presumption that they come to the court without bias, and it's through the jury selection process that the parties and the court ferret out that bias. Many of the jurors who were brought in were struck for cause. Many others were not. But ultimately, we have a fair and impartial jury. As I listen to the litany of issues and arguments and complaints raised by Mr. Brooks, I would note that they are all unsubstantiated, conclusory allegations and assertions without an adequate basis raised in law and fact. There's been several misstatements by Mr. Brooks. regarding either the record that's been made, items that's been provided to him, or the basis for the court either sustaining, I should say, or overruling objections, for an example. There's been a mischaracterization of his rights that he claims to have. As I have stated repeatedly, your constitutional rights are not absolute when you're in a criminal trial, meaning your First Amendment right is not unfettered. It is frankly no different why the case law is very clear. You can't yell fire in a crowded theater. No one has a First Amendment right to do that. In a criminal case, the parties have an obligation to follow not only the Constitution and the statutes that are applicable, but to follow criminal procedure, the rules of evidence. That is what circumscribes the rights that a defendant or the state has in a criminal trial. The issues you raise, for example, regarding subject matter jurisdiction are baseless, they're frivolous, and they're not anything this court needs to address further. The fact that you now are asking questions about whether this is admiralty court or a military court or a court of competent jurisdiction is frivolous. This court has jurisdiction over the criminal cases brought before it by the state of Wisconsin. In this particular case, these are allegations that criminal conduct occurred in the city of Waukesha. The city of Waukesha is within the county of Waukesha. This court sits as an elected official in the county of Waukesha to hear these types of cases. That is clear. The only argument or relief that I could discern through the course of those 50 minutes was Mr. Brooks's request that this case be dismissed for lack of subject matter jurisdiction. And as I have just indicated, this court has jurisdiction. It's not been raised. Let me rephrase that. The issue has not even been raised properly. There's never been a written motion. There's never been even an oral motion that would comport with 80201, which requires that the basis for the relief being requested be stated with specificity and be based in law and fact. The vast majority of the points that you raise, sir, are issues that you can raise on appeal. It is true, you have a right to an interlocutory appeal. I would not be the judge to decide any of those issues. So the fact that you complain about what I do, it's noted. The record is going to be very clear. All right? I have a court reporter who's taking down the record of everything that is said and done in this courtroom when we are on the record. And so I don't have to all the time say it's noted for the record because we're on the record. I sometimes do that to hopefully make it clear to you or to note it. I don't always do that, but I'm not required to do that. You raise issues concerning, I guess, plea bargaining. I have never been made aware that you would want to change your plea in this case, and that you're not aware of the state wanting to do that. That is the first time any such issue has been raised, and I see it as a distraction and as simply a statement made by you as part of the litany of things that you are not perhaps pleased with. As far as my conduct in this case, I already addressed those issues. I'm not going to revisit issues related to my familiarity with the father of one of the victims. That was done very early on. I made a very thorough record, and I gave the parties at that point an opportunity to address that after they had ample time to digest that information. While it's true you have a right to seek substitution of judge, it is not unfettered. There was a time limit for that. In fact, it was exercised because a prior judge was assigned to this case, and your attorneys on your behalf exercised that right of substitution. So to say that you have the right to seek recusal at any time would be a misstatement of the law. And even if you think that should be exercised or there is a valid claim for that, sir, it's not been raised in the proper way before this court. This trial will keep going. I still expect the basic rules of civility and decorum to be followed. That includes, sir, that when there is an objection to a question that you ask, that you wait for the state to indicate their objection and the basis for it. If I need additional information, I will ask for it. If I don't need additional information, I will rule on it. And I do expect that even if you disagree with that ruling, that you will abide by it and that you will move forward. Whether that's asking a new question, rephrasing a question that you've asked, I do ask that you follow that simple rule of decorum. And that's you not interrupt, and then you follow the rules of procedure. As far as the other issues you raise concerning your right to assistance of counsel, the record before this court over the many days that topic has been raised, even going back to the 2 afternoons of hearings this court held, I will not revisit those. I believe I honored your request to represent yourself as is required by the Constitution of not only the United States of America, but the Constitution of the state of Wisconsin. And that you made a very deliberate choice after being fully advised and aware of all the requirements that I needed to go through under the case law, both case law in the state of Wisconsin and case law from the 7th Circuit Court of Appeals, which not only guides this court, but this court must follow. I agree with the state and would draw your attention to the 2 cases that were cited. United States ex rel. George versus Lane, found at 718 F. 2nd 226, and Retzloff versus Moran, found at 2022 Westlaw 3045190. I let you put on the record all of those points in order to give you that opportunity to make a full record of the issues that you have believed that you are entitled to raise. But those sovereign arguments regarding written findings of fact, bill of particulars, regarding contracts that you enter into, regarding admiralty court, etc., they're baseless, sir. And this court need not address them further. Now, with that, I know it's 11:30, but I would like to get one more witness on before at least we break for lunch. The jury, of course, has been out for quite some time. So I'll instruct Madam Clerk to bring the jury out.
For the record, Your Honor, you didn't bring up the Higgins-Levine 415 U.S. 533 decision. That was not addressed, and the issues are still not addressed. There's still been no proof to anything that you said, anything that the prosecution has said. There still hasn't been.
As noted, and we will continue. Bring the jury out, please.
There still hasn't been
Mr. Brooks,
any proof.
I've addressed them
There
to the
still
extent
hasn't
that
been
I
any
will.
proof. There still hasn't been any proof. I never once The comment about me not flinching was when you said that there's 66 years of experience at that table. That's the comment I said that doesn't make me flinch. That was mischaracterized. That should be for the record. There's still been no proof.
Mr. Brooks, please stop. I'm not going to address whether there's verified proof or not of jurisdiction,
Because
whether
it's not.
there's anything along those lines. It is frankly not required under the law. You may disagree with that. You can take that up on appeal, whether that's an interlocutory appeal or whether that's a direct appeal if there is a conviction. But I'm not going to address it any further.
Because there's no verified proof.
There does not need to be, sir. All right, I
It does
believe the
need to
jury
be.
is coming out. Is that true?
In order for a case to...
All right. The
To
record
go
should
on, there should
reflect
be
that
proof.
the jury is coming out, and we are about to continue with the state's next
Not once
witness.
was the plaintiff addressed. That wasn't addressed. Where's the plaintiff? Where's the injured party? That's because
The jury will disregard the statements presently being made by the defendant.
Because y'all don't want the jury to know the truth.
The jury will disregard those statements
I understand.
made by the defendant.
I see.
It is not his opportunity to testify.
I see what's
They are
going on.
comments, and as such are to be disregarded.
I see what's going on. Ain't gonna work.
All right. Thank you, everyone. You may be seated.
It's not gonna work.
Attorney Opper, you may call your next witness.
Thank you. The state calls Hope Evans.
All right. Good morning, Ms. Evans. If you would please make your way to the witness stand. It is up a riser, so be mindful of that. When you get there, please remain standing. Raise your right hand. My clerk, Teresa, who's on my left, will swear you in.
Thank you. I don't have any other questions. Mr. Brooks may have some questions for me.
Any cross?
Yeah, and I object to being called that name again, and I don't consent to it again for the record. My name is Darrell Brooks Jr.
Noted.
Just a few questions. So at the time of October the 3rd, when you did a check to see if you would be needed, is it fair to say that at that time you wasn't sure if you would be testifying or not?
Yes.
Did you seek to testify in this matter?
No.
Are you aware of any plaintiff in this matter?
Objection.
Grounds.
Irrelevant.
Grounds.
Sustained. You don't have to answer that.
Grounds for the sustain, Your Honor.
Next question, sir.
Did you or your husband or anyone in your family that was present at the parade file any claims on the matter?
With who?
Do you understand the question?
Not really.
Please rephrase.
At any time, did you file a claim with any, I guess, the agency or anything like that
No.
in regards to the incident?
No.
Did any information that you obtained in regards to this incident have a complaint with it?
Objection made.
Grounds.
Sustained is to the form of the question.
Have you ever seen any complaint related to this incident?
Same objection. Your
Grounds.
Sustained is to the form of the question.
Do you know of any complaint with this incident?
Not sure I completely understand the question on that. What kind of complaint? I mean,
Please rephrase.
have you ever seen any issued charges in relation to this incident?
I'm sorry,
Grounds?
I did not understand what Mr. Brooks just asked, Your Honor.
I believe he said the issued charges.
I object to that on relevance grounds, Your Honor.
Grounds?
Overruled. She may answer.
I haven't really been keeping up with the news media on the trial. So, no, I haven't seen a list of the charges.
I was referring to if you had received anything from the district attorney's office about the charges issued.
No.
Are you aware of anyone bringing any claims or suits?
Objection.
Grounds?
Irrelevant.
Grounds?
Sustained. You don't have to answer that.
Grounds for the sustain, Your Honor?
Next question, please.
And you stated that you haven't really been keeping up with the incident, right?
Correct.
So that would that mean that it was your choice to do so, or you just kind of just disregarded it?
Objection.
Grounds?
Irrelevant.
Grounds?
Sustained.
Grounds for the sustain, Your Honor?
Next question, please.
After turning in the video to law enforcement, did you keep the video at that point?
Objection as an answer.
Grounds?
Overruled. She may answer.
The video is no longer on my daughter's phone. There's a copy on my phone that is still on there in case I needed to resend in the video. It has not been accessed since the day I sent it to the police.
So pretty much just keeping it just in case.
Correct.
Have you viewed it since turning it into law enforcement?
Objection.
Grounds?
Relevance.
Grounds?
It's been asked. It may not have been asked, but she answered it, so I'll sustain it.
So it'd be fair to say that seeing the video today would be the first time that you saw it since turning it into law enforcement?
Correct.
Just for clarity, you are not aware of any plaintiff in this matter, correct?
Asked and answered.
Grounds?
The
Is that an objection?
The objection is sustained. You don't need to answer that.
I think you said that you were contacted back in August, correct?
I received mail with the subpoena, yes.
Do you recall before August being contacted in connection with this incident?
Objection.
Grounds.
Repetitive. Irrelevant.
Grounds?
Sustained.
Grounds for the sustain, Your Honor?
Next question, please.
No grounds?
Next question, please.
Would you consider yourself an injured party in this incident?
Objection.
Grounds.
Repetitive. Irrelevant.
Grounds?
Sustained.
Reason for the sustain, Your Honor?
Next question, please.
No further questions.
Any redirect.
No, Your Honor.
Thank you, ma'am. You may step down.
Thank you.
It is just before the noon hour, so this will be a good opportunity for the court to break for lunch. I will say between an hour and 15 minutes, at least for the jurors. So all rise for the jury, please. Melissa, did as it relates to these, so yes, were the items provided to them? Thank you, everyone. Please be seated. State have available its next witness?
Yes.
All right, we'll bring the jury out.
Subject matter jurisdiction, Your Honor. Still have yet to be verified.
Your objections noted.
Was my ICF obtained by clerk of courts?
The one requesting the copies of various documents?
The one asking for the complaints.
Yes, my understanding is they're working on it.
Just wanted that clear for the record.
Just one or two ICF forms on that?
I sent one.
Okay. It was sent to me twice, and I just wanted to make sure it was only one. It appeared to be the same thing, but...
Is it in the queue, Your Honor?
It's in the case.
It
should be.
Thank you.
All rise.
All right, thank you, everyone. Please be seated. State may call its next witness.
State calls Master Trooper Mike Smith. Hang on.
I do.
What is it?
That is the scale diagram that I created as a result of the Trimble measurements that I took out at the scene.
Remove Exhibit 56 into evidence and request permission to publish.
Objection. I can't see it on my screen.
He's right.
Oh, I don't know why. We'll need to check the cabling. I can see it on mine.
What exhibit was that?
56.
Can you get Zach down here, please? Check the... Oh. Let me know when it's on the screen in front of you, sir.
I see it.
All right. Continue then. Oh, and Exhibit 56. Well, first of all, let him review it. It's been offered by the state. You've now had an opportunity to review it, sir. All right, Exhibit 56 is received. Permission to publish is granted. Go ahead. Cross.
Yes. This is kind of distraction still being on there. From your testimony, it seems like you've been doing crash reconstructions from quite some time. Is that fair to say?
Yes, sir.
Around 2004, I believe you said?
I was in the program from about 2002, but really started getting into full recons about 2004. You need a little bit of training first before you can actually go out and be on your own.
You stated that you worked with detectives in the process. Do you recall who that was?
Yeah, that was Detective Casey.
On getting the calculation of the speed, did you work with anyone on that side of your investigation?
No.
So it's pretty much just you and the detectives.
The detective did not assist me with the speed calculation. He just assisted me with obtaining the videos and also assisted me, excuse me, out at the scene where we did the testing.
I think the exhibit showed the building that had the camera. Do you recall which streets that were on along the parade route?
Yeah, that was in front of Cura Insurance on Main Street.
And the point A and point B, did those start from a cross street, or was it just the main?
The insurance company has cameras outside by the sidewalk. There's two of them. There's one towards the east and one towards the west, right at the front of the building.
Would you say there was a delay in finishing it, or did something cause you to kind of... Let me rephrase that. Was there anything that may have delayed you finishing the investigation quickly?
Can you rephrase? What do you mean by quickly?
It seems like there was two parts of it: getting the simulation done and then the actual diagram and things of that. Any reason why that couldn't be done closer together?
Well, first of all, it's not a simulation because a simulation is different than what we did. This was just some testing we did out at the scene. Secondly, as I mentioned earlier, I respond to hundreds of crashes. It depends on what I'm working on at the time. Once our reports are completed, they need to be peer reviewed. All that process takes time. So there's nothing that delayed my report. If you want to use me going to another crash, that possibly could have delayed it, but no delays that would affect the outcome of the report or the accuracy of the report.
No, I wasn't going to that part of it. I was just kind of curious to what may have spaced out the dates. That's what I was really getting at.
We do a lot of reports every year, and obviously we're not just doing one report a year. So every report is different. Every report requires different types of analysis. So there's really no set time on when we can finish a report compared to when we started. It just depends on what else is going on outside of our time in the office.
No further questions.
Any redirect?
No, thank you, Your Honor.
All right, thank you, sir. You may step down. You may. Statement called to next witness.
It's going to call Dr. A.B. Shield. I'm going to direct your attention to exhibit number 62. Do you see that in front of you?
Yes.
Is that the autopsy protocol for Leanna Owen?
Yes.
And can you just state for the record how many pages that autopsy protocol consists of?
It's not on the screen.
And it's not going to be on the screen.
Previously provided to Mr. Brooks.
Yes.
Do you have any additional copies today? Any chance?
I do not. We can make some.
You don't have that in your materials, sir? Do you have the autopsy protocol in your materials?
No.
You can provide that to Madam Clerk and we can make copies as well.
Was it intended for me to have or not to have? Just so I'm clear.
I can't answer that.
These autopsy protocols were previously provided to the defense.
All right, we'll still make copies. just going to run next door and copy them, and you can continue since we're on the first exhibit. Do you have Exhibit 62, sir?
It'd be the autopsy protocol for Leanna Owen.
I accept for value in return for value these documents, Your Honor.
The record to reflect that the defendant has a copy of Exhibit 62. Please continue.
Prepared to summarize your findings in the autopsy protocol for Leanna Owen.
Yes.
And does it accurately depict the injuries that are notated or described in the autopsy protocol?
Yes.
I would ask the court to accept Exhibit 62 and 163 into evidence.
Objection.
The objection to both, each objection is noted. They're overruled. Exhibit 62 and 163 are both received. Permission to publish, or I believe only 163 is what you asked me for, is granted.
Yeah, it was only one asked for.
Permission to publish 163. That's what I said.
Would that be consistent with it being struck by a moving SUV weighing approximately 3,300 pounds?
Yes.
Objection. Hearsay.
Overruled. Her answer, Ms. Young.
Nothing further, Your Honor. Thank you.
Cross-exam.
1 second.
You can take the exhibit now. Mr. Brooks? Your cross, please. Do you have any questions for this witness?
Just 1 second. I apologize to the court for taking so long. Do you know why the decision was made to why the decision was made for Jackson to become an organ donor?
Objection is irrelevant.
Sustained.
Did you end up doing any more autopsies besides those 3?
As it relates to this case or some other case, sir?
This case. To this case.
Did you hear the question?
Could he please repeat it?
Please repeat your question.
As far as this case, those are the only 3 autopsies that you did.
Yes, Jackson Sparks, Virginia Sorensen, and Leanna Owens.
Can you recall when they were brought to the hospital?
Virginia Sorensen and Leanna Owens were pronounced at the scene. Jackson Sparks was transported to the hospital.
I'm assuming that's Waukesha Memorial.
He was transferred to Children's Hospital of Wisconsin.
Upon first tending to the victims, were you in the knowledge of what happened?
Yes.
And that knowledge was given to you immediately?
Could you please repeat?
That knowledge was given to you immediately when you were called to tend to him?
Yes.
Were you called to attend to any other victims of the incident? Or just the 3?
Jackson Sparks, Virginia Sorensen, and Leanna Owens.
You didn't tend to anyone else? Browns.
Overruled. She may answer.
No.
No further questions.
Thank you. Any redirect?
No, Your Honor.
All right. Thank you, Dr. Shield. You may step down. May I have the exhibits, please? Thank you. Thank you.
Your
Say my
Honor,
call. Sorry.
Your Honor, if it pleases the court, may I have a few moments?
We can take a short break. I'll excuse the jury. We all can take about a 10-minute break. All rise for the jury, please. All right, it's 2:13. We'll be in recess for 10 minutes. We'll be back at 2:23. Thank you.
And after you were subpoenaed, did you, were you in contact with Attorney Opera after that?
Yes.
Did Attorney Opera ever state that she was the plaintiff in this matter?
Objection, relevance.
Sustained. You do not have to answer that question.
Grounds for the sustain, Your Honor.
You may ask your next question.
Were you ever made aware of the plaintiff in this matter?
Objection,
Grounds.
relevance.
Sustained. You do not have to answer that. Please ask your next question.
Grounds for the sustain, Your Honor, before I continue.
Ask your next question.
Do you even know if there's a plaintiff in this matter?
Objection, relevance.
Grounds.
Sustained.
Reason for the sustain, Your Honor.
Ask your next question.
No reason for the sustain, Your Honor.
Ask your next question.
Do you know of any claims filed in this matter by you or anyone else?
What are claims?
Any reports filed? Any filings made on your behalf or anyone you know?
I'm actually not sure I understand that.
I would object to it. It's vague.
Grounds.
Sustained. Sustained is to the form of the question.
Did you make any claim of being an injured party in this matter?
No.
Do you know of anybody that has?
Objection, relevance.
Grounds.
Sustained.
Reason for the sustain, Your Honor.
Relevance. Speculation. Vague.
Have you had any opportunity to view a complaint in this matter?
Objection, vague.
Grounds.
Sustained as to the form.
Have you ever seen a complaint in this matter?
Objection, vague.
Grounds.
Sustained as to the form.
Have you ever at any time had any interaction with the plaintiff in this matter?
Objection.
Grounds.
Sustained.
Reason for the sustain, Your Honor?
Vague relevance.
I would object to that sustain. You said vague and relevance, relevant to the
Sustain.
case.
Next question, sir.
It's relevant, Your Honor. Jury deserves to know.
It's overruled.
I respect that. Jury deserves to know, though.
Jury will disregard the last statement made by Mr. Brooks. It's not his time to testify. Comments made by the parties or attorneys are not evidence.
Have you ever seen the plaintiff in this matter?
Objection, relevance.
Grounds.
Sustained.
Reason for the sustain, Your Honor?
Same as before.
So that would be relevancy and vagueness.
Ask your next question.
Was today your first time ever seeing those exhibits that were shown?
No.
No further questions.
Briefly. Ma'am, to follow up on these diagrams that have been presented in court today, are all the findings that are contained in those diagrams from the autopsy protocol?
Yes.
Objection. Relevancy.
Overruled.
And ma'am, could you have brought in a it's Halloween, so we see them all over the place, but could you have brought in a skeleton and described the same injuries?
Objection. Relevancy.
Overruled. It's
Objection.
redirect.
Hearsay.
It's not hearsay. She may answer.
I could show you the broken bones on the skeleton. I couldn't show you the injuries to the soft tissues or the organs on the skeleton.
And if you had in a doll or a mannequin, that would be something that you could show the jury, just like you did in these diagrams, where the injuries, the external injuries were. Would that be a correct
Objection.
statement?
Relevancy.
Overruled. You may answer.
That's true.
So is there anything on these diagrams that were not contained within the autopsy protocol that were turned over to the state months ago?
Objection. Relevancy.
Overruled.
No, there's nothing on the diagrams that was not, that isn't listed in the autopsy reports.
In fact, if I had a blank diagram in reviewing the autopsy protocol today, if I put a blank diagram in front of you, could you have made these same markings right here? And it would have just taken time, obviously, but could you have done it right now?
Objection. Lead the witness.
Overruled. You may answer.
Yes, I could.
Thank you. Now I want to talk briefly about Jane Kulik's autopsy. You had stated that you had discovered a benign uterine fibroid. Is that correct?
Correct.
Did that in any way, was that a factor in her death?
Objection. Hearsay.
Overruled. She may answer.
No.
And with regard to Wilhelm Hospital, was the presence of a pacemaker in any way related to his death?
Objection. I asked that in my cross and she answered.
Overruled. It's redirect. It's proper. The state may ask it. You may answer.
No.
The coronary disease that you testified to on cross-examination, did that play a factor in his death?
Objection. Same reason.
Overruled.
Already
You may
answered.
answer.
No.
The thoracic fluid found in Mr. Hospital's lungs that you said did play a factor in his death. Is that correct?
Yes.
What caused that fluid buildup around his lungs?
Objection. Answered already.
Overruled. You may answer.
It was an injury to the thoracic duct that was caused by the impact of the vehicle to his body.
Nothing further, thank you.
All right, thank you. You may step down. My jurors are okay. Just thought we'd stand for a bit, but then keep going with testimony. So everyone may stand. do our little stretch break. We haven't done one of those in a while. Probably good thing the camera can't capture you. Stand for a bit. This chair hurts if you want. The non-chair. When you're ready, have a seat. All right, the state may call its next witness.
The state called Father Matthew Witter. Was this taken on the day of the parade? Does it appear?
It would definitely appear. I'm not familiar with the picture, but it would definitely appear.
That appears to be the street that you guys
Exactly.
walked on
Yep,
and the clothing
definitely.
that he was wearing.
Overruled. Father, do me a favor and just wait until the question is fully asked before you answer it. I know it can be very easy to anticipate, but the very nice lady in front of you is taking down a record of everything that's said, and it just makes her job a little bit more difficult if that happens. It's okay. So hopefully his answer was clear. If not, you can re-ask.
And I'm sorry, that accurately reflects what you believed you would have seen on November 21st of last year.
Yes.
I would ask that Exhibit 128 be admitted into evidence and published to the jury.
Objection.
Exhibit 128 is received and permission to publish is granted. The objection is overruled.
Now I'm also going to then show you on the screen in front of you Exhibit 121. Let me know when that's showing in front of you.
It is.
Okay. You had indicated that in front of the group was a banner. Is this consistent with what you're seeing, or can you describe generally what you're seeing in Exhibit 121?
That would be our group, somewhat close to the beginning of the parade route. So that's the banner. That's Bob carrying it on one side, and Jason Pekloff, as is noted, on the other side, where there's St. Matthias in the background. St. Joseph is kind of right in front of that, towards the beginning of the route.
Okay. And there are other names that are associated with people. There's a box with their name with a red arrow going from the person to the name. Are all of those correctly diagrammed?
Camila certainly is. Jason certainly is. Adair certainly is. Maria certainly is. Juan, I couldn't say definitively that that's him. And Jose Perales, I believe that's him, but I couldn't say definitively on that particular angle.
Okay. And with regard to Jason Pekloff, specifically, since we've identified the other people in this photograph through Exhibit 129, that is Jason Pekloff, and he's correctly named in this diagram?
Yeah, definitely.
Objection. Everybody was not positively identified.
I would note that the witness identified most with certainty, others without. So the jury should just keep that in mind at this point. I don't believe there's been an offer, though, or a request to receive it just yet. So I'll withhold any of that.
And Your Honor, I'm going to move Exhibit 121 into evidence, ask that it be published with the understanding that Father Witter indicated that Jose Perales Alvarez and Juan Marquez, it would be consistent, but he cannot say with 100% positivity that those are those two individuals.
Objection. It was not said with certainty whatsoever. The answer was he's not sure.
Exhibit 121 is received as noted by the state. Permission to publish is granted.
Sir, again, in looking at this exhibit, which is 121, other than Jose Perales Alvarez and Juan Marquez, which you indicated you weren't positive about, the other people whose names are and arrows are on that picture, you can positively identify them?
100%.
Okay, thank you. Now I'm going to show you what's been marked as State's Exhibit 122. And again, is this consistent with a picture that was taken at the very beginning of the parade where the other picture was taken from?
That's correct.
Okay. And there are two names associated with two individuals on this picture. Can you positively identify that those individuals are the people in this picture?
Objection, leading the witness.
Overruled.
Yeah, William Mitchell and Yamilat Perales, that would be 100% certain.
Thank you. I would ask the court to admit Exhibit 122 into evidence and publish it for the jury.
Exhibit 122 has received permission to publish. Granted.
And again, this accurately reflects the identity of William Mitchell. If you can just circle William Mitchell in the photograph, it is a touch screen in front of you.
I should.
And Yamilat Perales Alvarez. Thank you. Moving on to Exhibit 123. Can you identify the individuals who are named in this exhibit?
Objection, the names are on there.
Question was whether he could identify the individuals who are named. So
That's a big arrow pointing to there.
your objections noted. It's overruled. You may answer the question.
So each of the people, Benjamin Hallmark, that arrow is correct. Maria Perez, that is correct. That is Luke Hallmark. Marisol, that would be Marisol. And then Gregoria, I would say 100%, I would attest to that picture.
And again, does this look to be taken in the same vicinity as the other pictures I've shown to you?
Yeah, definitely, it's towards the beginning of the route. Exactly, that's probably St. Matthias right there, and St. Joseph will be right in front of us.
I'd ask the court to admit Exhibit 123 into evidence and to publish it for the jury.
Objection, relevancy.
Overruled. Exhibit 123 has received permission to publish is granted.
Again, sir, I'm just going to ask you to circle the people associated with the names as I call them out. Benjamin Hallmark, I think you had previously identified in Exhibit 129, but where is he? And if you can circle him. Okay. And Maria Perez.
Maria.
Luke Hallmark. Marisol Lopez Gutierrez. And Gregorio Romelia Perez, I think you said you know her as Romy.
Yeah, she also goes by Romy.
Thank you. We can take Exhibit 15 down. So when you looked around and saw the red SUV, did you hear the impacts first, or did you see the red SUV first?
I saw the red SUV just flying on the left side. I mean, flying is a relative word, but it was, going fast. It was going faster than anyone in their right mind would be driving in that scenario.
Could you estimate the speed?
Objection, hearsay.
Overruled. You may answer.
From being on that street in other occasions and kind of walking over there, the speed limit is 25. The car, in my estimation, was going faster than I would see a car driving in normal times down that street.
So in excess of 25 miles per hour?
Objection, hearsay, leading the witness.
Not hearsay. It's a clarification question. Your objection noted. It's overruled. You may answer.
I would say yes.
And I'm just going to go through the remainder. If you saw them, or either that night or in the following days, let me know. And if you know that they were injured, Maria Alvarez Dominguez.
Objection. It's hearsay.
It's not hearsay. It's asking about his knowledge, not what he heard. It's so you may
injuries
answer
would
the
be
question.
Maria was injured. I don't know the full scope of her injuries.
And how about Gregorio Romelia Perez?
She was very, very, very severely injured. Major issues.
Could you observe what those injuries were?
Objection. Hearsay.
Overruled. You may answer.
Pelvis fractures, and she was in rehab for about 4 months with still walking with a cane.
She still is walking with a cane?
That's correct.
Lori Loken?
Lori sustained some major heart issues, so she had a major procedure on her heart.
Marisol Lopez Gutierrez?
I don't know the full extent. Marisol was impacted. She suffered I believe a fracture, wrist fracture. Some other major soreness. She's healing.
Adair Lopez Gutierrez?
Adair was the car ran over him. He didn't suffer any major physical injuries, but was impacted.
Juan Marquez?
Juan suffered a major leg fracture, has had a couple surgeries.
David Marquez?
David was struck, took on some bruising, but no major injuries.
Jason Peckloff?
Objection. Hearsay.
Overruled. You may answer.
Jason suffered a severe concussion and some ankle injuries, an ankle injury.
Yamilet Perales Alvarez?
Objection. Hearsay.
Overruled. Go ahead. You may answer.
Yamilet was came very close to losing her. Major head trauma. Was severely hurt.
Jose Perales Alvarez?
Objection. Hearsay.
Overruled.
Jose also was very severely hurt with leg injuries. He's had about 10 surgeries at this point. Still walking with a crutch.
And Camila Perez Gonzalez?
Objection. Hearsay.
Overruled.
Camilla had an orthopedic injury. He's had a couple surgeries.
You testified to observing quite a few injuries. How can you assess the injuries just by looking at the people?
Can you clarify what you mean by that? Like, what are you getting at?
For example, if I was to see someone injured laying on the ground, I could essentially say, "Oh, it looks like this," but how can I be certain that that's what it is? So my question is, being that you observed a lot of injuries, how are you able to assess what they were just by looking?
Well, the question mischaracterizes his testimony, so I'm going to ask that you rephrase.
How did you know the injuries just by looking?
It still mischaracterizes his testimony. That's not what he said. He was asked about whether he was aware.
Yeah, that he observed injuries. So how could he know
He observed some, so you need to be specific as what point in
the
time.
injuries that you saw at the hospital? How were you able to say for sure what those injuries were just by observation?
Yeah, so some of it is seeing people at the hospital, and then part of it then is, so there's the immediate seeing people in the hospital, and then there's the later times of seeing people in the hospital or seeing people in other contexts.
So would it be fair to say that you were told those injuries either by medical professionals or by the people?
Exactly. So if people would say, "This is my injury," I would believe them. If they'd be in the hospital, if I see people with crutches, wheelchairs, then I would say that's probably accurate.
But you didn't know for sure yourself until you were told.
Yeah, I'm not a doctor, so I'm not the one diagnosing an injury. I can observe what they say, I can observe what I see, and then I see people with crutches, wheelchairs,
That's what
and
I
I'm
was
like,
getting at.
there's probably truth there.
Do you know, because you testified to seeing those, some of those people after the incident, would that be fair to say?
Yes.
Do you know if any of the people you saw after the incident filed any claims in the matter?
Could you clarify by what you mean by claims?
Did they file for to be an injured party in the matter, or did they file for any medical bill support or anything of that nature? To your knowledge, do you recall any of that?
We certainly told as many people as possible to get involved in the Waukesha parade support and other means of help. I can't speak specifically for each person what they did or did not do.
Can you explain to the jury what you mean by the support that you are referring to? Was that like a group formed, or was that sort of like an event of a GoFundMe account or something like that? Can you give some clarity on that?
Yeah, there was the Waukesha Parade Fund that was, I think, an international type of thing. There was, our parish had a fund. There were GoFundMes. There were any number of different things. There were different encounters to allow people to come together and talk about what had happened and seek start healing from the emotional part of it.
And by international, that would be assuming worldwide. That'd be fair to say?
Yes.
So it would be fair to say that there were financial interests attached to this incident.
Objection is how it relates to this witness's testimony.
Grounds.
Sustained.
I should try to answer the question.
No, I sustained it. You don't have to
Okay.
answer that.
All right.
You can rephrase, but as it relates to how it was asked in this witness, I'm sustaining it.
Well, it was actually because he referred to some GoFundMes being set up and anything. So my question was, being that it was a wide-ranging scope by him saying international.
What's your question? I sustained the objection.
Was there any financial interests attached to this incident?
And I'm going to object for the same reasons before.
Grounds.
It's vague, unclear, overly broad. Sustained as to the form of the question.
Any idea how much money was raised for the I guess I would say GoFundMe's, groups, support?
Objection as it relates to this witness's
Grounds.
testimony.
I'll allow it a little bit of leeway as it potentially could relate to bias, not of this witness. He made no claim, but go ahead if he knows. Subject to you following it up with other, I guess, witnesses later on.
I know, so the Catholic community of Waukesha had an opportunity because people wanted to give, and so there were $73,000 that came into the fund that I'm aware of, the Catholic community of Waukesha, that we dispersed in different ways. There's still, I think, $3,000 left. That's for kind of community healing events. What the end of what GoFundMe's reached, what the Waukesha Foundation Fund reached, I don't know. But I know the Catholic community of Waukesha was $73,000. Yeah, the specific, I couldn't say 73 what, but 73,000, I think.
And did that go straight towards the victims to help them in any way?
So an example would be there are many people that could not work because of being hurt, or they had situations where a loved one was severely hurt and they had to be at home or going to the hospitals, nursing homes, and taking care of them. So there was, and I have no idea the ins and outs of, payment of hospital bills and things like that, but I know people were, they could not go to work because of some of these scenarios.
Well, it'd be fair to say you wouldn't call a bus a car, though, right?
Objection, argumentative.
That's argumentative, sustained. You don't need to answer that one.
When asked earlier, when you were asked about if you saw anyone else on the ground or something to that effect, you said as time went on, you had observed someone else laying on the ground. Can you explain what you mean by as time went on? Was that a significant time that passed, or a very short time that passed at that point? Do you recall?
My testimony is there were 3 people that were right in front of me, and I really spent time. Father Pat then was taken to the side as he waited for a squad to come. I really stayed with Maria because there weren't a lot of people around there first, so I really kind of focused on staying with her. From looking up and waiting, there'd be officers or, different medical personnel, whether they were, I can't say, I was, how do I say this? This would be a point of clarification in the sense of, I believe that I was subpoenaed to come in and talk to the DA. I'm not sure if that's a subpoena or that's what the correct wording is. I was told to come in and talk to the district. I'm not sure if that's a subpoena, but I believe it would be more than come in if you want to. I believe it was kind of like you need to come in, not if you want you can, if not, don't. I'm not sure what the terminology for that is, but that's how I would take it. If that's a subpoena.
No, that's not a subpoena. The subpoena is when you actually get the subpoena paperwork by mail, or I don't.
Mr. Brooks, you need to ask a question.
Can I get to it, Your Honor?
No, because you're trying to define something, which would be testifying, which you cannot do at this time. So the jury will disregard his last comment, but go ahead and ask a question of this witness.
Something else. Wow.
Mr. Brooks, that was inappropriate. Do you have any other questions for this witness?
Yes,
Please
I
ask
do.
them.
During your conversations with Attorney Opper in September and October 1st, when you received the subpoena, at that time, were you provided the complaint in this issue?
What do you mean by complaint?
The complaint would be a reference to the charges in this matter. Paperwork that would state the charges.
Objection, Meg.
Grounds.
Oh, Rose, he may answer if he's able.
I mean, to me, seeing what happened and seeing everyone that was hurt,
No.
To me it was very obvious what this was about.
Did you see at any time any paperwork related to the charges in this incident?
So there'd been the subpoena sheet that would have had your name and any number of different.
What do you mean my name? What are you referring to?
I believe it would have said Darrell Brooks on it.
Are you aware that I don't identify by that name?
Objection, argumentative.
Sustained.
Sorry.
So is that what your subpoena said? Was that the language of your subpoena? The logistics?
We've been down this road under 906.11, Mr. Brooks. You're not, I need you to ask a relevant question to this witness.
That was relevant. He said what was on his
No,
subpoena.
you've talked at length about the subpoena. So under 906.11, move on to a new topic, please.
Are you aware of who the plaintiff is in this matter?
Objection, relevance.
Grounds.
Overruled, he may answer.
I believe that you would be, or excuse me, you're the defendant.
I would be the plaintiff?
Excuse me, at my mind. You're the defendant, I believe. The plaintiff would be.
If you know, do you know who the plaintiff is?
You know, all those who were hurt under the title of the state of Wisconsin. That's how I would identify it.
That's how you would identify it. So, do you know if anybody who was hurt that identified as the plaintiff?
Objection, relevance.
Grounds.
I think this witness has testified he's really not sure what the plaintiff is. He kind of guessed. He gave an assumption.
Sustained.
He did.
Foundation.
He did answer the question though.
Sustained. Next question.
So, to the best of your knowledge, the plaintiff would be the representative of the people.
Objection is relevance.
Sustained. You're now asking him to make a legal conclusion, which I will not have him do. It's also not relevant.
Do you know of any injured party who claims to be the plaintiff in this matter?
Objection, relevance.
Grounds.
Sustained. Mr. Brooks, under 906.11, please move on to a new topic.
Are you aware that only an injured party could be the plaintiff in this incident?
Objection,
Grounds.
relevance.
Sustained also misstates the law. You don't have to answer that. Mr. Brooks, new topic, or under 906.11, I will close the cross-examination.
How does that mischaracterize the law? An injured party has to make the claim.
Under 906.11, you haven't asked a question. I will give you one more opportunity. Don't question me. Please ask a question of this witness. The jury will disregard his statement as it mischaracterizes the law, and he is not testifying. He's asking questions at this time.
Are you aware that the state of Wisconsin is an entity and cannot claim to be an injured party in this matter?
Objection.
Grounds.
Sustained. All right. Your cross-exam is now closed under 906.11. Does the state have any redirect for this witness?
Briefly.
Go ahead.
Sir, prior to the red SUV coming through your group, did you ever hear a horn honking?
Objection.
Overruled. You may answer, sir.
Objection. Hearsay.
It's not hearsay.
I personally didn't, but
That's fine. Now I'm going to show you State's Exhibit 15 again and ask that that be published to the jury. This has already been admitted into evidence.
Go ahead.
Objection. What was the answer to the last question?
The record speaks for itself. Next, the witness can consider the annotations.
And again, you previously identified the individuals in the Catholic Communities of Waukesha box. In looking at that box again, were all those people on the road as part of the Catholic Communities of Waukesha when the red SUV went through?
Objection. Leading the witness.
Overruled. You may answer, sir.
Definitely, 100%.
And we can take that exhibit off the screen. One final question. When you spoke with District Attorney Susan Opper in your meeting that you testified to, did she ever tell you what to say today?
Objection. Hearsay.
Overruled. You questioned his credibility. You questioned his talking to the state. He may answer the question.
The only
Go
reason
ahead.
why I'm objecting, Your Honor, is because
Your objection's noted.
Attorney Opper is not asking the question, so how would Attorney Basie know what
Mr.
Attorney Opper
Brooks,
said?
I'm not going to explain the legal procedures. You go ahead, ask the question. You may answer when she does. Do you recall the question?
Yeah, I do. She did not.
Okay.
No.
Did she tell you to tell the truth today?
Objection. Relevancy.
Sustained as to the form of the question.
Everything that you testified today, is it truthful?
Objection. Hearsay.
Overruled. You may answer.
Yes.
Nothing further, thank you.
All right, thank you. You may step down. I would like to get through one more witness, but I want to take a short comfort break for everyone, so I'll rise for the jury. Thank you. Mr. Brooks, not now.
Not allowed to.
Not now. The jury is in this courtroom, and you will show respect for them and for this court.
Respect for them would be
Mr. Brooks.
telling them the truth.
Stop. I'm putting you on notice that you are on the verge of this court creating a curative instruction about your frivolous arguments. I will not have you claim legitimacy for what are debunked, frivolous, sovereign arguments.
Then
That is why
prove it.
your questions
Prove it.
are being
Prove that it's
objected
frivolous.
to,
Prove
and
that
why
it's frivolous. Prove it.
all the cases that we've already referenced, sir. We are in recess. We'll be back
And
in
prove
5
it.
minutes. Thank you, everyone.
I don't agree to an estoppel. Can you prove it?
Attorney Opper, you just wanted to address timing.
Well, and I understand. Let me say this, Judge. The ebb and flow of this trial has been very difficult to predict, not through any fault of the court, but by events. We do have 2 witnesses here ready to go. If the next witness goes relatively smoothly, would you consider letting us call the second one and maybe wrapping up by about 6 o'clock?
Yes.
Okay, thank you. If not, he can come back tomorrow, but he's been here twice already.
No, we'll keep going. I prepped the jury for that yesterday, so we're good. I'm going to have the jury brought out. All right. Bring the jury in, Madam Clerk.
And I object to that.
To the timing?
Yes.
Your objection's noted. We're going to make up for lost time from yesterday.
So can we adjust the subject matter jurisdiction?
No,
then,
we
since
cannot.
we're talking about that? We're not going to address that either. That's still not going to be proven, right? It is frivolous stuff. That's going to get pressed every time. So. I've yet to prove subject matter jurisdiction. Any jurisdiction at all, rather.
The jury will disregard the comments being made by Mr. Brooks at this time. They are a mischaracterization of the law.
Absolutely not. They are absolutely not. They are.
All right, thank you, everyone. Please be seated. The state may call its next witness.
The state would call Lucas Hallmark.
All right, Mr. Hallmark, if you would please make your way to the witness stand, which is on my right, up one riser. When you get there, please remain standing.
And did you notice anything different about your surroundings as you heard the screaming?
Objection. I asked the form of that question and it was answered.
Overruled, he may answer.
Can you just repeat the question, please?
Sure. Did you notice anything other than the screaming that seemed unusual when that happened?
Objection, different question.
Overruled. I'm not sure what the objection is, but you may answer.
Clear with the objection.
So after my initial thought of that vehicle was just a lost motorist, or they didn't know actually what was going on, that thought faded very quickly, and I realized that something was drastically wrong based on the fact that that vehicle was traveling at a significant rate of speed towards our direction.
When you first saw the vehicle or the top of the red vehicle, approximately how far was it away from you?
When I first looked back and saw it, I would estimate it to be about, I would say approximately 200 feet. My recollection is that it was near Curry Insurance.
You testified, RA, as to where your position was at that time, correct?
Yes.
Where were you in relationship to the group that you were walking with? Where were you within that group?
Sure. So our group, we were just kind of walking together behind a white banner. There was no set, I guess, method of us walking. We actually, as we were continuing down the parade route, some of us moved forward, some of us moved back, depending on how the kids were doing. But at that particular time, I was near towards the back, so I would say the middle of the back of the group, and more towards the center of the road.
And which shoulder did you look back over when you heard the screaming?
I turned to my left.
And that's when the vehicle was approximately 200 feet away?
Objection, hearsay.
Overruled.
Yes.
What did you see next?
The vehicle came, I recall the vehicle coming right at to where we were walking. It started hitting folks in our group, and the only thing that I could remember doing was I had my 3-year-old in my left hand, and I had my 9-year-old in my right hand. As we were walking down the parade route, my 7-year-old was kind of walking in front of us at the time, and I remember realizing that we were going to get hit, and it was going to come very quickly. And so I grabbed my 3-year-old as hard as I could, and I threw him towards the curb. At the same time, I tried to grab Benjamin at that point and throw him with my 3-year-old.
Oh, Benjamin, is he the 7-year-old?
Yes.
And he was in front of you, you testified?
Objection, leading the witness.
Overruled. The answer may stand.
To the best of my memory, yes.
Yes, okay. And you stated that you had your 9-year-old in your on your right side. What's the name of your 9-year-old?
Elliot.
Objection, relevancy.
Overruled. I'm sorry, what was the name?
Elliot.
Thank
Elliot
you.
Homework.
When you saw the vehicle and as it was coming towards you, could you estimate the speed that the vehicle was traveling?
Objection, hearsay.
Overruled. You may answer.
I estimated the vehicle traveling about 30 to 40 miles an hour.
What is the speed limit in that area of Main Street?
25 miles per hour.
So you threw your 3-year-old to your left, you stated?
Towards the curb, which would have been to the south.
And how about Elliot?
I don't remember at that point what happened with Elliot. As the vehicle passed us, I don't know if he got ripped out of my arms when the vehicle came through. I just remember that I kind of got, as I turned to my left, I pivoted on my left foot. I got clipped to my left foot, and the vehicle passed us, but I don't recall what happened with Elliot.
How about Ben?
Ben, I saw him stumble and kind of roll from where the vehicle came towards the curb to the south.
Now, when you said you got clipped, what clipped you?
Objection.
Overruled.
It had to have been the vehicle. I had an abrasion on my left heel, and then I had white sneakers on that night, and they had black marks along where I had my abrasion on that same part.
What was that consistent with, those black marks?
I would guess the vehicle tire.
Where was your wife?
She was standing a little bit behind and then to the left of us, so she would have been a little further at that point, a little bit further to the east and then to the south.
I'm going to play approximately 5 seconds. It's a 1 minute and 26-second clip. I'm going to play the first 5 seconds and see if you recognize this video.
Yes.
If we can stop it and go back to 00. Does it accurately reflect what you observed on November 21st, 2021?
Objection to the relevancy. Who took the video?
Overruled.
Does this video contain footage of the Waukesha Catholic community in the parade on that date?
Objection. Hearsay.
Overruled. You may answer.
Yes.
I'd move, I'm sorry. Oh, okay. I would move State's Exhibit 140 into evidence and ask that it be published to the jury with sound.
Objection. Still hearsay.
The objection's noted. It's overruled. Exhibit 140 is received. Permission to publish is granted.
And I'd ask that it start playing now.
Maybe, we'll see. I mean, it's actually at the Elks Club Lodge. It's like, see, it's really cool.
Or maybe. I went with like a friend. Sounds cool.
Yeah, it's really...
Is it on Thanksgiving?
Saturday, November 20th, 2021.
That passed.
What?
That passed. Oh, yeah. It's the 20th today.
Oh,
right?
that was...
Oh, no, it's the 21st.
Ooh, so it already did already.
It happened yesterday.
Yep, it happened already. Ah, whatever. Whatever, though. That's okay, whatever.
Oh, those outfits are so cute! Young lady, where is your winter jacket?
Did you see a red SUV traveling westbound in that video?
Yes.
Would that be consistent with what you saw coming from behind you on November 21st prior to what you just described?
Objection. How do we know the direction? How do we know it's westbound?
Your objection's noted. It's overruled. The witness may answer.
Yes.
Thank you. So I'm going to show you some still shots from that video and just ask if they accurately reflect what you observed.
Objection to the relevancy.
I have to see them. Are you going to do that electronically or hand them to the bailiff?
I'd like to do it electronically if I can.
Go ahead.
Show Exhibit 135 just to the witness. Sir, do you identify that as a still shot taken from the Exhibit 140?
I recognize the photo you're seeing is from the video?
Yes.
Yes.
Do you see a purple line on that exhibit?
Yes.
What does that reflect?
Objection.
Overruled.
The witness.
The parade route.
Hold on, I'm sorry. What was your objection?
The witness.
Leading, did you say? Overruled. You may answer.
It indicates the parade route.
Sir, direct your attention to the area where the Catholic communities of Waukesha, where there's a list of names. Do you see that?
Yes.
And are all those people that are listed in that box, were they in the roadway at the time that the red SUV went through your group?
Objection. Hearsay.
Overruled.
Yes.
Okay. Thank you. And again, it's there's a line with that box that's associated with this a yellow star. What's the significance of that, if you know?
Objection. Leading the witness.
Overruled.
I'm sorry, is that still Marisol?
Objection.
We can pause here.
Pause. Who is that, if you know?
So this is still Marisol.
Said objection.
Overruled.
So this last yellow line I just drew, that's still Marisol. Right here where I circled as being covered by a red blanket, that would be Gregoria Perez. And then over here, that would be Jason Pechloff.
Stop the video at 58 seconds. Sir, I'm going to direct you to Exhibit 162. We're almost done. 2 more exhibits.
I know the video continued. I just didn't know if you wanted, because I apologize.
That's fine. Let me go back,
Okay.
sir. Let me redirect your attention to Exhibit 154, where we were, which is 58 seconds. If we can publish that for the jury, since it has been admitted into evidence. And again, if you could
Objection. Are we going to another exhibit? She just said 162.
We're back at 154, she indicated.
Sir, in terms of the appearance of that hat, I'm not going to ask you if it's the exact same hat that was on Eileen's head in Exhibit 162, but is the same, is that the same type of hat in terms of has the same wording on it, same color, same palm color as the hat that Eileen was wearing in Exhibit 162?
Objection. Hearsay.
Overruled. You may answer.
It looks remarkably close. Same color, same patterns of the lines, the writing, and then with the top on it. Yes.
Thank you. I have nothing else.
All right, you're crossed, sir.
So you saw all those videos that were shown, all exhibits rather, all 12, 13 of them. You saw all those before today?
I don't recall there was 12 videos. To best of my knowledge.
126, 15, 137, 136, 135, 140, 178, 160, 154, 162, 92, at least 11 or 12.
Mr. Brooks, I'm going to strike your comment because you cannot testify. You did not let him answer. Let him answer first, and then you can ask follow-up. The jury will disregard the statement made by Mr. Brooks. Go ahead.
I believe there was only 3 or 4 videos, but there was numerous screenshots or photos taken from those videos.
That's why I said exhibits. Have you seen all exhibits before today?
I had seen those exhibits, yes.
And do you know who took any of those exhibits, the videos or still shots?
No, sir.
So how were you able to see them?
Can you rephrase the question, please?
How were you able to see them if you don't know who took them?
I saw them on the screen. I'm not sure I'm following your question.
Before today, you said you saw them before today. That's what you just said. So I'm asking, I asked after that, do you know who took them? You said no. So how could you I guess I'm asking, how would you know if you don't know who took these videos? How were you able to see them before today?
I believe they were collected by the police department as evidence.
And that's how you saw them?
That's how we were able to view them afterwards, yes.
Do you know when you viewed them?
I don't recall.
Did you view all 12 of them in their entirety at the same time, or were they at different dates?
Yeah, back to the form of the question.
Grounds.
Did you view them all in their entirety? Again, it makes it seem like he's referring to videos, and if he is, that's fine. If he could just clarify videos or exhibits.
Sustained as to the form of the question, please rephrase.
Exhibits.
Can you just repeat the question, please?
At what time did you see all the exhibits in their entirety? Was it the same day or was it different days?
I don't recall specifically. I just reviewed the exhibits, the photos, not the videos, but the photos, as you're explaining in these exhibits, prior, just in preparation of my testimony.
In preparation of your testimony, what do you mean by in preparation of?
Preparing my testimony for court, making sure that everything maybe kind of recall my memory, anything to that nature, making sure that everything is accurate in what I'm going to testify to.
If everything you're going to testify to is truthful, why would you need to prepare for it?
Objection.
Grounds.
Sustained as to the form of the question.
Why would you need testimony preparation?
This is a pretty significant incident. I wanted to make sure that I was prepared fully for being here and testifying.
Wouldn't it be easy to just come in and recount what you saw?
Objection. Argumentative.
Grounds.
Sustained. Please rephrase.
Is it fair to say that it would be fairly easy to state what you saw that evening?
Yes.
So why exactly did you feel the need that you had to prep yourself?
Objection. Argumentative.
Grounds.
Sustained, also asked and answered.
I'm going to direct your attention to Exhibit 154, which is a video. So that's clear for the record, not a still frame. It's a video.
You want to put up for him?
I want it put up for him.
All right, it's been received before. Put it up, please.
Can we go to 41 seconds?
Sure. Thank you to the state for assisting. 41 seconds, you said?
41 seconds. Is it fair to
Hold
say
on,
that...
do you want to wait until the jury has it in front of them?
Yeah.
Okay.
Sorry.
It's okay, there's a delay. Sometimes it's long, sometimes it's short. Seems to be long right now. All right, we're good. Go ahead.
So in this exhibit, which is a video that's paused at 41 seconds, we can see two people laying on the ground. Would that be fair to say?
Yes.
Can you see any of the two people's faces right now as it's paused?
No.
So it would be fair to say that you can't positively say who that is from this part of the video that's paused right now.
Well, based on my experience, based on clothing descriptions, obviously Adir and Marisol are mother and child, and body structures, that's how I'm able to identify who they are.
What do you mean by body structure?
Well, Adir is a little bit smaller and Marisol's a little bit larger, and that's how I have memory of who she is.
Would you agree that they're kind of like bunched up, like kind of balled up?
I would agree that Adir is, yes.
Can you see faces?
No, sir.
So it would be fair to say that you don't know for sure who that is.
I'm pretty confident that's Marisol and Adir.
Pretty confident?
I'm very confident.
So why not be very confident the first time that question was asked? Grounds. Grounds.
Sustained.
Let's go to 58 seconds and pause. Right here in front of us, we see 3 people kneeled down. We see someone with a pinkish blanket covering them, and we see a lady with a black coat with a white kind of like top to it. Is that fair to say?
Yes, sir.
Can you see the face of the person laying on the ground under the pink blanket?
No, sir.
Would it be fair to say that you don't know for sure who that is?
As I described before, I'm very confident that that's Marisol that's laying on the ground.
And how can you tell that from the picture that we're looking at now?
Well, not specifically just from this picture, but like I stated before, as the video was moving, we could see clothing descriptions, body structure, who she's laying next to.
Is it fair to say that the exhibit is not moving right now? It's paused.
Yes, sir.
And it's paused with not being able to see who's under the pink blanket. Would that be fair to say?
Yes, sir.
So how can you say for sure who that is?
If I was to just view this video or this photo without any other context, you're probably correct. I probably wouldn't be able to identify any particular person, but because of the video and how it moved and how I was able to see people, I was able to confirm that'd be Marisol.
And you came to that conclusion because you've seen these videos before today, or these exhibits rather before today. Would that be fair to say?
No, I come to the conclusion with my memory of being there at that night.
But you did state, just so we have clarity, that you in fact saw these exhibits before today. Would that be fair to say?
Objection asked and answered.
Grounds.
It has been asked and answered, but I'll let the witness answer that question again.
Yes, sir.
Towards the, I don't know what that direction would be. I'm guessing that would, if you're looking at it the way I'm looking at it, it'd be towards the right.
Right this way?
We're coming back a little bit more. Right where the lady with the white coat is,
Mm-hmm.
You see a few people, it looks like 3, kneeled over someone that is under a blanket with, it looks red with like snowflakes or something on it. You can see like a black, I don't know if that's like a shoe or, I'm guessing that's a shoe or a boot or something to that effect. Is that fair to say that you can see that?
Yes.
Can you tell who that is just looking at it right now?
I know that that's Gregoria, yes.
Can you tell who it is looking at it right now? Can you see their face? Can you identify them right now?
I cannot see their face.
So it'd be fair to say that you're not sure who that is.
I am sure who that is.
And you come to that conclusion based on what we're looking at right now at this moment.
Objection.
Grounds.
This characterizes this witness's testimony.
Grounds.
Sustained.
Let's go to 136. Same exhibit in pause. Is it fair to say we can see someone with laying on the ground? They have like a bluish jacket. You can only see one arm, so the sleeve. The jacket is blue. It looks like they have like something red next to, which is obviously a lady in a gray jacket, white hat. A guy in a red, looks like a hoodie, and someone else to their right, I would say, and a jacket and a cap with looks like a baseball cap. Would it be fair to say that you can see that?
Yes.
And the person that's laying on the ground, can you see their face?
No, sir.
So would it be fair to say that you don't know for sure who that is?
I'm sure I know who that is.
Based on what we're looking at now, you can tell who that is.
Based on my recollection of the incident that night, I know who that is.
Based on what we're looking at right now on the screen, can you tell who that is? You
Yes,
can
sir.
see their face.
I know who that is. I cannot see their face.
So it'd be fair to say from this picture, you're not sure who that is.
Objection, Ms. Characterizes
Grounds.
witness's testimony.
Sustained.
To the right of the screen, right here. Can't tell how many people is kneeled down right there, but it's obvious that they're attending to somebody. Would that be fair to say?
Yes.
Can you see who that is that they're attending to in any way?
Not from this vantage point, no.
So it would be fair to say that you don't know who that is that they're attending to, correct?
I know who they're attending to.
And you can tell that by what we're looking at right now?
Objection.
Grounds.
Characterizes the testimony.
Grounds.
Witness testified as this video was going through who he believed each person was.
Who he believed. But we're looking right now.
Mr. Brooks, let me rule on the objection.
Sorry, Your Honor.
Thank you. Overruled, he may answer.
Can you repeat the question, please?
Can you tell from what we're looking at right now? Can you tell who that is that they're attending to?
You cannot see that that is Jason Petchoff behind them, but that is who is laying on the ground right there.
And you can tell that by what we're looking at right now. You can see who that is.
No, based on my recollection of the incident is why I know who that is.
I'm saying referring to what we're looking at, not your recollection, what we're currently looking at right now. Can you tell who that is that's being attended to from based on what we're looking at right at this moment?
You cannot see who the individual is.
Can we go to 2 minutes and 30 seconds and pause? Can we erase that circle and arrow?
It's been done.
Okay, I see. Thank you.
You're welcome.
Right in front of us, we can see is a group of people standing over someone who appears to be laying on the ground. Would that be fair to say?
Yes, sir.
It looks like they have a Scooby-Doo blanket over them. Would that be fair to say?
Yes, sir.
By what we're looking at right now at this moment, can you tell who's under the Scooby-Doo blanket?
I know who that is.
Can you tell by what we're looking at this moment? At this moment right now, can you tell who's under the Scooby-Doo blanket?
No, sir.
Can we go to 241 and pause? Would it be fair to say that right now we're looking at what appears to be could be a police officer, some kind of law enforcement, could be security guard or anything, but some type of law enforcement. We see someone, it looks like a woman who you can't see the top of her head, but you can see like her chin and her bottom lip has black jacket. And right in between those, the law enforcement and the woman, you can see that someone's laying on the ground, and you see 3 people attending to them. Would that be fair to say?
Yes, sir.
Can you tell by what we're looking at right now? Can you say exactly who that is?
100% confident because I'm in that photo.
And is that you standing over in front of him?
I'm standing over my son.
Or not standing, I'm sorry, I didn't mean to cut you off. Kneeling in over the top of who's on the ground.
Yes, my son is crying because he just got struck by a vehicle and I'm trying to console him.
That wasn't the question. That's you kneeling over with the hat, and it looks like a grayish, I don't know if that would be a hoodie, but like looks like it's some like bluish black to the sleeve. Would that be you?
I'm wearing a gray sweatshirt. My son is wearing the blue jacket.
I could be mixed up. I apologize for that. So it would be safe to say, by what you just said, you were 100%. You were adamant, 100% that you knew who that was. Mm-hmm. Would that be fair to say?
Yes, sir.
But you didn't have that same enthusiasm for everybody else that we were just looking at. Would that be fair to say?
Objection. Mischaracterizes this witness's testimony.
Grounds.
Sustained. It's also argumentative.
And out of all the exhibits.
Are we done with this exhibit?
Oh yeah, we're done. I'm sorry.
All right. Just take it down, Madam Clerk. Thank you. Go ahead.
Out of all the exhibits that you were shown during the initial questioning, you're not sure who took any of those videos?
No, sir.
There was quite a few exhibits that were shown. Would that be fair to say?
Yes.
You stated that your 9-year-old was in your right hand and your 3-year-old was in your left hand. Would that be fair to say?
Yes, sir.
You stated at some point that your 9-year-old was ripped, or you didn't know if your 9-year-old was ripped out of your hand. Can you explain what do you mean by ripped?
At the point where I lost contact with him is about the point where the vehicle had come through, so I didn't know if it was the force of the vehicle taking him away from me that forced our hands to be separated, or if we had just separated hands prior to that. But based on my recollection, it was simultaneously as the vehicle had passed through us.
And was that 9-year-old injured?
Yeah, Elliot was thrown in the air and he was knocked unconscious.
And what happened with your 3-year-old that was in your left hand?
I threw him with my left hand towards the curb. He did not get struck.
When you say threw him, what do you mean by that? Was it?
I was holding on to it. Sorry.
A quick toss, or was it like a harsh push, or define thrown?
I picked him. I was holding on to him with my left hand. I grabbed him off the air and threw him as far as I possibly could because I knew that he was going to get hit by a car.
Do you recall if he was hurt in the throat?
Objection.
Grounds.
Relevance.
Overruled. He may answer.
I didn't actually see him that night because I stayed with my other son at the hospital. But as far as my recollection, I don't think he was injured from that, no.
In a summary of your report, do you recall stating to the officer that you were interviewed by that you saw a second unconscious person laying on the ground that you further described as a Hispanic female?
Yes, sir.
Would it be fair to say that in your testimony here today you gave names? That'd be fair to say?
Yes, sir.
Why not in the summary of your report did you give names and just say a Hispanic female?
I'm just going to object to the form of the question. He's indicating that it's Detective Hallmark's summary in this report it's not been established. Okay.
It's in the form of the question.
I was referring to him already testifying that he had knowledge of everybody that was in his group.
Rephrase your question, please.
At the time of your summary, did you know the identity of the Hispanic female that you referenced?
An objection to the form of the question. It's not his summary
Ground.
per se.
Sustained as to the form of the question.
So should I say in the summary that you gave? Do you recall that comment?
Objection mischaracterizes the summary.
Grounds.
Sustained as to the form of the question, please rephrase.
In the summary that was given by the officer that you gave the report to, do you recall that statement?
I'm sorry.
I am going to object. The witness has answered the question. Again, I would just indicate for the record that I believe what Mr. Brooks is looking at is a different officer's report that summarizes the statement that that officer received from Detective Hallmark. With that understanding that that's what it is, I would ask Mr. Brooks to maybe ask his next question with keeping that in mind.
Objection to being called that. I don't identify by that name nor consent to being called that name. My name is Darrell Brooks Trial.
Next question, sir.
I made reference that it was
Next
by
question.
another officer.
Next question, please.
You made reference to your son being attended to by two men. Would that be fair to say?
Yes, sir.
At the time of the incident, did you know who those two men were?
No, sir.
And when did you learn of the identity of those two men?
It was a couple days after the incident. I learned the identity of one individual that was attending to my son.
Do you know if they, or do you recall them giving you any additional information that you didn't have that night?
Yes.
Do you recall if they were active participants in the parade or just spectators? Did they give you that information at any time?
This individual was a spectator.
Do you at any time recall making a statement in the summary that was given by another officer? Do you recall making the statement, you threw Charles and Benjamin as hard as you could towards the south curb?
Yes, sir.
If you already stated that you threw your 3-year-old, which you just said was Charles, and you also just acknowledged that you threw Benjamin.
Objection as to the characterization. He acknowledged that the summary that Mr. Brooks is reading said that he threw Benjamin.
He answered the question.
He did not. I believe there's an objection. I'll sustain it as to the form of the question. Please rephrase. It also mischaracterizes the... Well, I'll just leave it at that. You may ask your question.
So did you throw Benjamin as hard as you could to the south curb, or did you see Benjamin struck by the vehicle?
So when the vehicle was coming and I threw Charlie, I knew that Ben was in front of us, so it was the same motion with my left arm to get Benjamin and Charlie out of the way. Obviously, I didn't get Benjamin completely out of the way of the vehicle.
Any idea why that was not in the summary?
I don't recall.
Grounds?
He answered it. He said, I don't know. His answer may stand.
No further questions.
Any redirect?
Real brief. Sir, the identifications that you made in the exhibits that were shown to you on direct examination, are you 100% confident in those identifications?
Yes, ma'am.
Hearsay.
Sorry.
Overruled. You may answer.
Yes, ma'am.
What is that based on?
My recollection of the incident.
Thank you. Nothing further.
All right. Thank you, sir. You may step down. Ladies and gentlemen of the jury, thank you so much for your patience, as it was the court who wanted to keep moving a little bit tonight. I know we're a little bit late. I will read the instruction, and then you will be dismissed for the day, and we'll see you tomorrow morning. In this case, after the trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. With that, you are excused for the evening. All rise for the jury, please. I just have a couple of housekeeping matters. Please be seated. My recollection, there's been a couple of exhibits that were annotated and captured that I don't know were specifically moved in. I'd ask the parties to look at that and let me know if there's any requests as it relates to that. I also want to provide the parties with a copy of an incident report. This relates to an incident last week from the 6th, where I told the parties, or I asked the Sheriff's Department to provide me with a report regarding the incident with Mr. Brooks and being removed from the courtroom, and I believe he may have even filed like a use of force form or something like that, but I wanted to have it notated or noted in the record, and so that incident report has been filed with me. I have a redacted report so that the Sheriff's Department is in compliance with that. The parties are getting an unredacted report. The unredacted will be kept on file but sealed, and then the unredacted will be and the redacted will be what's available for the public should anyone request that. So that's one thing that's coming. Then, just as a courtesy, even though I'm not required to do this, sir, I did follow up on your inmate communication form with our clerk of court, Monica Paz. She has, I have the response here, and I'm going to provide that for you so that it's notated on the record. And so there's a cover letter, and then there's some documents pursuant to your request. I'll give that to and then along with, on the back, will be that incident report. So that's being provided as well. And then the state, you'll get a copy of that incident report. I don't know if you want a copy of what Mr. Brooks was requesting, but at least that inmate communication form has been filed into the case. I believe it's documents the state could simply pull off of the electronic filing system in any event. And then lastly, I had marked, this is the exhibit 6 that I previously had ordered struck. I just wanted to make a record that it's marked, it's in this envelope, it will be kept with the file for any potential use later on. I just hadn't made a record of that, so that's there as well. That does cover all of my housekeeping issues with that. Given the state's request or Attorney Opper's request to start late tomorrow, and frankly, given the late night tonight, we will start tomorrow at 9 a.m. Was that enough time for you?
Yes. I was actually going to withdraw my request because we have another jam tomorrow in that we have a witness that we have to guarantee to get out of here by noon. So my request is perhaps, if the court's willing, we could start at 8:30 with the preliminary matters. We could still have the jury come in at 9, but if there's any preliminary matters, we could start with Attorney
I need to let
Basie.
them know. I told them 9:15 in my note that I gave to Mike, so I don't know if we can still get a hold of them. We probably can.
Okay.
So if maybe someone's going to need to tell them quickly. So I need to stay here so I won't step off, so we can keep going. But so 9 o'clock it is.
Okay.
You want to start? How about we do 8:45?
Have the jury here at 8:45?
No, parties here at 8:45.
Parties here at 8:45 without
jury
me.
by 9.
Attorney Basie and Attorney Witchell will be here at 8:45. I'll be here at 9.
All right.
Okay, thank you.
All right. Then, just Mr. Brooks, those things were provided to you.
Yeah, I set for value, return for value these filings, and just very briefly, so we can get out of here. I have to raise this issue.
What issue is
My understanding, how can someone who's not an injured party testify on behalf of somebody who is an injured party?
Mr. Brooks,
and it still be
I'm
charged?
not addressing this. It is a frivolous argument. You have a misunderstanding of the law. We are in recess. I am leaving the bench. Thank you,
Okay.
everyone. We're in recess.
So that's a tacit agreement. We're not.
Darrell Brooks, case number 21 CF 1848. Appearances, please.
Zach Witchow.
Sir, state your name for the record, please.
I'm here as a third-party intervener in this matter. As authorized representative for my client, I accept for value and return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments. And for the record, I do not consent to or agree to being called that name that you have identified here today.
What is your name?
Brooks.
The record should reflect that the individual known to this court as Darrell Brooks is present in person in custody in street clothes, specifically a suit and tie and a mask. I just also want to make a record quickly that a number of documents were left by Mr. Brooks in the holding area just outside the courtroom. They have been put on his desk today. It's all of the autopsy protocols that were provided to him yesterday, the hard copies, that is, the diagrams that were presented in court related to those protocols, and a copy of the pretrial offer. So I just wanted to make that record. Hold on. Not right yet, please. So I have been advised that all of the jurors are here and ready to go. I presume the state has available its next witness.
Yes.
We do. We'd also move State's Exhibit 162A into evidence.
As to 162A, Mr. Brooks, any position on that?
Yeah, I object. I haven't even seen it, first of all. And second of all, again, for the record.
Mr. Brooks, I'm just dealing only with the exhibit right now. Sorry for the interruption, but I need to do that without interruption from you. 162A was a screen capture that related to an annotation that a witness made. I believe that was during witness number 34. Yes, that was Mr. Hallmark. And so based upon that, Exhibit 162A is received, and I will so advise the jury when they come in. Sir, I'm not going to address any preliminary matters at this point. I've already addressed a number of things yesterday. The jury is to be brought out.
No, there was some things that needed to be discussed about the paperwork from yesterday.
We'll take that up on a break. You can look over it. You can make a note and pass it to
I've
my clerk.
already looked over it, Your Honor. With all respect, I think there's some things.
Mr. Brooks, I'm not going to deal with it right now. It's paperwork. I just wanted it notated that you left it, and now it's being provided to you again.
I'm not referring to that paperwork.
I'm not dealing with the paperwork from the clerk of court's office either. I am not the custodian. We're going to bring the jury out.
Okay, but she should know that she's trying to
Mr. Brooks,
get me to pay.
Stop. I am not addressing
it. It has to be addressed, Your
All right,
Honor,
I'm
'cause
going
if
to
I
take
don't-
a quick break and make sure the jury is ready and we'll come off the
if I don't
bench.
address it now.
All right, thank you. The jury can come on out.
So we're not going to address this civil matter?
No.
I was told to pay for something under a civil statute.
Mr. Brooks, I am not the custodian. Bring it up with the clerk of court.
How
I'm
can
not
I bring
addressing
it up
it.
with the clerk of court? How am I supposed to do that? So that makes me wonder if it's a
Mr.
civil
Brooks,
case.
the jury's coming out. I'm not going to
it's-
address your request
if
for
it's
open
civil-
records.
if it's civil,
I'm not
then
the
it needs to
custodian
be
of the records,
who's
sir.
being sued? My Sesty Trust is being sued? Civil is a
Mr.
civil
Brooks, this
matter.
is an irrelevant matter that you're attempting to bring up in the presence
If it
of the
was-
jury. The
I
record
was
should
not. I was
reflect
trying
these
to bring it up
interruptions.
before the jury came out, Your Honor.
And I
know
told
that.
you I wasn't going to address it. Please.
Okay, so it's a civil matter. Who's being sued? My Sesty Trust? Because how can I be
Mr.
sued?
Brooks, you're talking about an irrelevant matter between you and the
It
clerk
wasn't,
of court.
it wasn't irrelevant
So-
when I got the paperwork from the clerk of courts. I was simply
Mr.
trying
Brooks,
to address it.
I'm not going to address it. The jury will
So I'm
disregard
being
these
sued?
irrelevant
This is a civil
comments.
matter? We haven't addressed subject
All right,
matter
thank you,
jurisdiction yet at all
everyone.
either?
Please be seated. The jury
So
will
we're not gonna
disregard the
address subject
statements
matter?
Mr. Brooks is making about subject matter jurisdiction. They are a misstatement of the law.
Yes. No,
All right,
it's not.
and
just like this is a civil case.
Mr. Brooks, the jury's here. Please
Just like
show
this is a civil
respect
case.
and decorum.
According to this document, this is a
Mr.
civil
Brooks,
case,
please stop.
which means someone is being sued. Civil is a suit.
Mr. Brooks, you're talking about an irrelevant matter.
I have the
I'm
paperwork
starting
sent
the
by the
trial.
clerk of courts right here that says it's a civil matter.
Mr. Brooks
So
has
what's
nothing
being
to
sued?
do with
My
this
Session
case.
Trust is being sued.
I have no idea what you're talking about. So,
I got the paperwork right here.
all right, I'm
How
going to
do you not
excuse
know
the
what I'm
jury
talking
right
about?
now, given this disruption. I'll rise for the jury.
This should be properly addressed before the jury even comes out. That's why I tried to properly address it before we even went on the record.
Mr. Brooks, stop.
I'm not gonna. This is.
You are
I
not
was
being
given
respectful
this
to
paperwork
this
by you,
proceeding
Your
or
Honor,
to
with
this
all
jury.
respect.
No,
With
it's
all
not.
due
With all due
respect.
respect,
With all due
stating that
respect,
doesn't make it
I was given
respectful.
this paperwork by you,
Mr.
from
Brooks,
Monica Paz.
stop talking
the
till the
clerk of
jury
court.
is out.
Okay,
Thank you.
So why couldn't we address this before they came out?
I'm
That
not
was the
going to
time-
address it,
That
bottom
was the time
line.
to address it, though. We're supposed to do all the addressings before the jury comes out, before we start the matter.
Please
I was
be
trying to
seated.
simply address paperwork that was given to me by you, Your Honor. That states that
Mr.
this-
Brooks,
it states that
you
this
have
is a
interrupted
civil
me
matter.
repeatedly. You are on the verge of being removed to that courtroom. I don't want to
On-
do
on
that.
what-
I want you to stay here.
on what
But
fact of the
you
law, Your
keep
Honor?
interrupting me and bringing up irrelevant matters. I told you yesterday, as a courtesy that was provided to you, so that you would frankly not complain that you didn't get it as quickly as possible. Okay, I am not the custodian of the records. If you have an issue with what was provided to you, how it was provided to you, then take it up with the clerk of
She
court.
can't
But
charge
from
me.
now on, I am not going to be the messenger and give you documents that you request to the custodian of the records or from the custodian of the records. They will simply have to be delivered to you at the jail. But that is in response to your discussion or whatever we want to call it this morning. I'm not taking it up. All right? It is irrelevant.
It needed to be noted for the record.
It doesn't
Because
need
it
to be
was-
noted, sir.
You
All right,
gave
the
it to
jury's
me-
coming
you gave
back
it to me
out,
in
and I'm
open
going
court.
to warn you, if you bring this up again, I will pause and I will remove you to the next courtroom for being disrespectful, for being interruptive, for being disruptive, and for bringing up irrelevant matters in front of this jury. You will forfeit your right to be present for the direct examination of this witness.
I object to that,
Did you
Your Honor.
hear what I said, sir?
No, I did not. I object to that, Your Honor.
Well, you can
And-
object, and your objection is noted, but if you
For the
interrupt
record-
when this jury
for
comes
the
out,
record-
they will go, I will have them taken out again, and you will be removed to the next courtroom.
You can't, what is the legal basis for that ruling, Your Honor?
Illinois versus Allen, sir, and all of the
And-
other cases that
and it
I've
doesn't
cited
say
previously.
anything
I'll
that-
make the appropriate record. Stop interrupting me. The jury's coming out. We're continuing with this trial despite your repeated efforts to disrupt.
That's a
Yesterday,
mischaracterization
sit
of the
down.
record.
Yesterday alone, sir, 17 interruptions, not including the opportunity that I gave you where you spent 50 minutes, okay, discussing what were primarily either irrelevant or baseless accusations and requests not based in law or fact. I was abundantly patient with you yesterday.
And you still haven't
And-
verified by proof any of what I
And
said,
none
Your
of that
Honor.
is required, sir.
Because it
And
is. You can't verify
your
any proof.
belief
Where's
that
the
that's the
subject matter-
law
where's the subject matter
doesn't make it
jurisdiction?
so, Mr. Brooks. Your belief that these are legitimate legal positions
They are.
doesn't change the law and doesn't make it so.
It's
So,
clearly
again,
relevant because you didn't want to.
I'm going to step off and give Mr. Brooks 5 minutes to cool off, and when that
I don't
happens,
need
I'm
to
bringing
cool
the
off.
jury
I'm not
out,
angry at all.
and then we will
I just wanted
continue.
to. I don't.
Thank you, everyone. Please be seated. All right, the jury can be brought out, please. I need to stand here because the camera needs to stay so they don't catch the jury.
Once again, not addressing the subject matter jurisdiction yet again.
Maybe a little bit more on the procedural, just, yeah. But yeah.
All rise.
Thank you, everyone. Please be seated. Ladies and gentlemen of the jury, while you were not with us, the state moved Exhibit 162A, and I did receive it. With that, who do we have on the witness stand?
The state calls Assistant Chief Craig Learman.
All right, sir, would you please stand and raise your right hand, and my clerk, Teresa, will swear you in.
Do you recall what happened at approximately 4:39 p.m. that Sunday afternoon?
Objection.
Overruled.
Yes. Can you tell us?
Sure. Standing at that location, the parade was coming from my right to my left, so from the east to the west.